Hello everyone, myself Viren Sharma, Public Administration Faculty at Vajiram and Ravi. We are going to discuss a topic today which has been changed in terms of dimension after the Supreme Court judgment regarding can governor exercise pardoning power, commutation in the cases of death penalty. Usually as a convention it was existing that only the president can exercise the pardon, reprieve, remission in the cases of the death penalty. So in the today's discussion, we will focus upon the judicial powers of governor of a state and judicial powers of President of India, and we'll try to understand that can the governor also exercise the pardoning powers in the cases where it is a death sentence given by the state law, under the state law by the judiciary. So let's begin with this area, and it is about judicial powers. Of governor and president. So we will cover it in the way that first of all, powers of president, under Article 72, powers of governor under Article 161, and thereafter Supreme Court judgment A. Perarivalan versus State of Tamil Nadu 2022. The judgment which has changed the dimensions of this entire execution of judicial powers. When we talk about Article 72, powers of the President, as per Constitution, the President of India under Article number 72 can exercise these judicial powers. There will be two things to understand. One, what is the extent or on what subjects he can exercise these power? And second, what are these powers or these pardoning powers? They are a combination of multiple provisions. So when we talk about President of India, he can exercise these judicial powers in the cases where a person is convicted under court-martial. Court-martial is a term used for your armed force laws, the laws applicable for armed forces. So in those cases, the president has a power to exercise the pardoning because this is a subject exclusively under union. Then if a person is punished or convicted under union law, then also the President of India has a power to exercise pardoning. And third, in all cases of death penalty, these are the wordings used in the Bayer Act under Article number 72, which talks about the extent of these powers. Because extent is also mentioned under Article number 73. And as per that idea, whichever subject comes under union list or Parliament has a power to make law, on those subjects, the President of India can exercise these judicial power. And these powers are a combination of 5 terms: pardon, reprieve, respite, commute, and remit. This remit is also known by the term remission. Commute is also known by the term commutation. And each of these has its own application. Means if we are taking all the charges free, charges are also waived off, and the person is no more a guilty, that thing is done by the concept of pardon. Reprieve is about stay on execution of sentence. So it's like a temporary relief. Then respite is about giving a different punishment. And this is done in case of some special circumstances. Like a person has been given death sentence by the court, and after listening the judgment and the punishment, the person may have lost the mental balance. So we are not in a position to punish the person who is of unsound mind, and then it become a special reason to convert his death penalty into the life imprisonment, and he may be given the treatment through the mental asylum. In such circumstances, the special cases will appear, and then that will be considered by respite. However, in general way, on the mercy petition, the death penalty can be converted into life imprisonment. Rigorous imprisonment can be converted into simple imprisonment, and those things can be done by using the concept of commutation. So here also change of punishment. And then remission is about reducing amount of punishment. So reducing amount of punishment is by the remission. In these cases, suppose somebody given a 14-year rigorous imprisonment and the person is getting released after 10 years. A person has a life imprisonment, and after completion of 20 years of imprisonment, he approaches for release from the jail. So when they are released early, rather than taking them throughout their life for the punishment, after 20 years when you are releasing them, then that becomes a concept of remission. And these are 5 powers which are combination of a term pardoning power exercised by the president. Now, what is the condition which exists for the governor of a state? When we talk about governor of a state, under Article 161, governor also have pardoning power. And as per constitution, the governor also have power to grant pardon, reprieve, respite, commute, and remission of sentence. Means all the 5 terms which exist for the president also exist for governor of a state. And what is the extent of these powers? Extent of these powers will come from article number 162. And in these cases, it will be applicable for a punishment given under state law. So the subjects which are under jurisdiction of state legislature, those subjects are subject to jurisdiction of governor with respect to these judicial powers. As a result of this, you will find there is no difference in terms of the pardoning power of governor as well as president when it comes to power point. The difference will be in terms of extent. Governor do not have power in case of court martial, and governor do not have a power in case of a person punished under union law. But if a person is punished under state law or a person is punished under concurrent law, then in those cases, the state also have a power to make a law on the concurrent subjects, and that's why it creates an overlapping between the two. And in these contexts, the governor can also be approached for the mercy petitions. This is as per constitutional provision exists. And over the year, one convention got developed that in the cases of death penalty, only President of India will exercise pardoning power. That was developed as a convention. And this entire system came into change when in 2021, in the state of Tamil Nadu, A. Perarivalan approached to the governor under Article 161 for release from the jail, and this is actually the power of remission. And the unique thing is the State Council of Ministers under Article 163 advised the governor to release the prisoner, but the governor of the state has denied this release after around taking 1 year time span on the grounds that it is the president who has a power to exercise pardon in cases of death penalty, and governor of the state do not enjoy this power. This reply of the governor was challenged in the Supreme Court, and that resulted into emergence of this case law, A. Perarivalan versus State of Tamil Nadu, 2022. Because approach was in 2021, denial took place by the next year, and then it reached to the Supreme Court, and that's why the judgment has been in 2022. Here, the same issue came, means Supreme Court has summoned the central government also, governor also, to seek their opinion. And when the opinion was given by the AGI as well as from the state representing the state governor, that in cases of death penalty only the president has a power. The A. Perarivalan was a person convicted in the Rajiv Gandhi assassination case. Initially, they were having death penalty. This death penalty was already converted into life imprisonment. And now the life imprisonment, they were asking for release from the jail. That's why they were asking for the remission. And in this case, the Supreme Court has said, if the governor cannot exercise these remission power under Article 161, then this Article 161 will become a dead letter of the Constitution. And therefore, the governor of the state also enjoys pardoning power in the cases of death penalty, because even if a person punished under the concurrent law or the state law, the governor of the state is given this power of pardoning, respite, reprieve by the Constitution itself. And if this power is restricted, then Article 161 is going to become the dead letter of the Constitution. And by this judgment, the governor's power with respect to pardoning has technically been broadened. That means the convention is out and the interpretation by the court is now applicable. So governor can also exercise pardoning in the cases of death penalty, as per the Supreme Court's interpretation and existence of constitutional provision. I hope we are now clarified with this kind of portions that can governor exercise pardoning power in cases of death penalty. So answer is yes. If only president can exercise, that is not correct as per now this interpretation of the Supreme Court's judgment. That is all. Thank you so much. Bye-bye.